Hello, everybody, and welcome to the McGuireWoods Annual U.S. Supreme Court Preview. My name is Matt Fitzgerald, and I will be the moderator today. I want to welcome everybody who's online. We have local attorneys, clients, McGuireWoods people, and also members of the John Marshall Center. Welcome to all of you. This is going to be an open discussion among us here, the several of us, but we welcome your questions. Please type them in. I think there's a way on your screen for you to type in any questions. We'll answer as many as we can and address them sort of as we go, but please feel free to do that. First, to introduce the panel, we have Ashley Peterson, who is an associate here in the Richmond office, the former clerk to Chief Judge Carnes on the 11th Circuit. Say hi, Ashley.
Hello, everybody. Happy to be here. Looking forward to discussing some interesting sentencing issues and the Foreign Sovereign Immunity Act today.
Great. Thank you. And next we have Caroline Burton, also an associate here in Richmond. She clerked for Judge Jordan on the 3rd Circuit.
Hi, everybody. I'm so excited to be here, and I have the pleasure and challenge, I think, of taking us through one of the most watched cases at the Supreme Court this term, and that's the abortion cases that you've probably heard a lot about in the news. So really looking forward to it.
And thank you for taking that on. Next, our last panelist, we have Michael Francisco, who is a partner in our D.C. office and a recent former clerk to Justice Gorsuch.
Welcome, and I'm excited to be part of the panel and look forward to talking about the non-controversial topics of God and guns.
Right, God and guns. And I am Matt Fitzgerald, the moderator. So we have here 4 members of the McGuireWoods Appeals and Issues team to present these. So first, before we get into the individual cases, it makes sense to get our bearings a little bit. Where has the court been recently? Where is it going? We have a new member of the court, Justice Barrett, who will be this fall starting her 2nd term on the court. Here's a little background on Justice Barrett. So basically, a law professor for about 15 years. She worked in big law very briefly at Baker Botts. And actually, I checked on this because I noticed she was an associate at a litigation boutique and then an associate very briefly at Baker Botts. And apparently, Baker Botts swallowed up this litigation boutique. So she didn't jump. She was just at one place that got bought for a couple of years. And then she went into junior professordom and then senior professordom for 15 years. Notably, perhaps, Barrett is the only sitting Supreme Court justice now who did not attend Harvard or Yale. She brings some geographic and pedigree diversity with Notre Dame Law School. All right. So altogether then, we have these 9. And I thought it was interesting to put up here, we'll talk about their ages and the future in a second, but just to look straight at years on the court, Justice Thomas at 29 now, he's actually going to get to 30 this month, which is a major milestone. It makes him, I think he's now the 16th longest serving of 115 justices in history, and he has about 6.5 years to go if he wants to catch William O. Douglas. But what I think is notable about this is there's really 3 tiers here of seniority. Thomas and Breyer, who are the last left from that long period in the 90s when one court was all together, the same 9, who have these remarkably long tenures, in the top maybe 10% or so of justices. And then you have the set who came in with Bush and Obama. Kagan, who still feels new to some of us, has now been there 11 years, and so, they're not new by any sense. And then, of course, the 3 Trump appointees who are just barely getting started. So it is interesting because by age, the breakdown is similar to this, but not exactly the same. So here they are, their current age, how old they will be in the randomly selected moment of January 2025, and also in January 2029, just to lay out future administrations. And here, there are less, the obvious tranches of seniority are a little bit less clear. It really seems like, so just to be clear about that, if Justice Breyer is still on the court in January of 2029, that would make him the oldest active justice in history ever. So realistically, it's likely that he will retire or move on in either this administration or the next one, which has obviously been a source of much discussion. But this is their ages. Of course, you can see from this, with Justice Thomas still being 73, yet having already been there 30 years, the possibility of him reaching William O. Douglas's 36.5 years is certainly out there. Numerous recent justices have served into their 80s.
Matt, and I was just going to add another interesting sort of demographic point that I think, you know, people might be thinking about, especially as Michael said, you know, this term we've got God, guns, and abortion as sort of the headline cases. You know, it's a really interesting point to me is that 7 members of the court identify as Catholic, and the other 2 identify as Jewish. And so that's quite different from, you know, the United States population. There might be a lot of speculation as to how, you know, those religious affiliations play into any decision making, but I just thought I would flag it as sort of a, you know, unique point as well about the justices' backgrounds.
Yes, there are a remarkable number of Catholics, and there have been for some time, even as they're turning over now. That was true, you know, when the court was a little different in the last few years as well.
Yeah, absolutely.
I cannot explain that, though, but it is interesting. So, all right, let's go on. So the new argument structure for 21 to 22. As the court has done for the last, so recently, last term, the court did its arguments by telephone. They changed up the questioning format a little bit, and they changed it so that each justice, in order of seniority, would have several minutes to question each counsel as they went. They started with 2 minutes to let the counsel actually talk before that. And this term, they're keeping that structure, even though they're going back live. So it's going to be interesting. Obviously, they've already heard some cases. Some of them have gone over time significantly because of these. They keep on going, essentially, when each justice only has a couple of minutes. They want to get in their questions, and then yet they have more at the end. So Justice Thomas is sort of all of a sudden the big speaker in this, which is a real renaissance moment for those of us with a fondness for Justice Thomas. It is notable that within a couple of weeks, so they started this format in the spring of 2020, and within just a couple of weeks, Thomas had asked 63 questions already. He's basically filling up his couple of minutes that are allowed. And that, of course, is a vast change from what it has been, and you can see the press sort of responding to that favorably, and not, but relatively few people have said mean things about it, so I appreciate that.
I'm just curious, Matt, as someone who's argued before the Supreme Court, and then Matt and Michael, you know, coming from your clerkships, like, do you think that the new argument structure is easier or harder on advocates who might go before the court?
What do you think?
I think most of the consensus is that it's easier for the advocates to face questions seriatim, one by one, from the justice. Although, I've listened to a few arguments in this current term, and it's going back more to the free-for-all format. Even in the justices' sort of allotted time, there's been a few interruptions. And so I think you'll see a little bit more of a hybrid return to the hot bench. even as they try to impose a little bit more order and pacing.
So some of the justices are interrupting the other justices' time?
Justice Kagan this morning in the Sarnaeff argument interrupted Justice Kavanaugh's time in a fairly pointed way.
Wow. That is interesting. So we'll see whether they can hold to their own rules, basically.
Yeah.
Do you think that if we assume that the argument structure will slowly slip back into more of a free-for-all, do you think that we will see Justice Thomas quiet down again, or do you think that there's sort of a new era here where he is going to maybe, as the more senior member of the court, feel some responsibility to continue questioning?
I think if it truly goes back to a free-for-all, he will quiet down again. I do think that. I think the fact that he has been questioning now under the new format fits with what I think is his philosophy about why he wasn't talking before, which basically came down to everyone else was talking too much. And so if everyone else is going to go back to talking too much, I think he will quiet down again. But I think court watchers have appreciated hearing from him in the moment, and especially as the most senior. So he's the first one, at least the first who is not the chief. I think it starts with the chief. He's the first who's not the chief. It really gives him a nice opportunity. I mean, other justices will grab onto his questions and keep going. You know, if you're going to be the most senior and you're going to speak early, it is a nice moment. So I hope they continue it so that we can keep hearing from him. But I think if it erodes, we won't.
Do you all think that we lose something without the crosstalk, or the being able to question one another's questions?
I think maybe a little something is lost there, but I think it's interesting that some lawyers think it's easier with the 2 minutes allocated for each to just focus on the one justice and hope another justice doesn't come in and randomly interrupt. But I don't know, because the one argument that I had there in 2018, one of the takeaways that I thought was just having the 9 instead of a normal panel of 3 was different and arguably easier for the counsel, because it was harder to get pinned down anywhere. I mean, so if you're answering a difficult question from one justice and that justice doesn't look persuaded and they're coming in with they're going to kind of keep pushing you backward and backward. Some other justice comes in with a friendly or even an unfriendly but unrelated question, which you then turn to. It's sort of, you do get jerked around, but you get jerked. The jerking around can be a rescue, I guess, as much as anything else. I find some of the most difficult and awkward encounters in arguments to be when some judges are quiet and one is just relentless on one issue. They don't agree and they won't let it up, and there's nowhere else to turn. But with so many and with them open questions, there's sort of always somewhere else to turn. That's what I thought. All right, so that's the argument structure. The shadow docket, another thing that's made a lot of splashes recently. Basically, the shadow docket, an amazing term invented by a law professor, I believe, in 2015, and it reflects the court's emergency docket. Normally comes to them in terms of requests for stays, injunctions, things that are bubbling up much faster than the normal way. And so there's been a lot of press about the way that the court is using the shadow docket. Are they doing things that they shouldn't do? Are they being more aggressive than they have been in the past? Certainly it's more active in terms of more requests are made to them, more actions are taken on those requests. But I think it's an open question, really, how much that's coming from the court versus externally.
Matt, I would just add to the shadow docket list you have that death penalty cases traditionally come up frequently in an emergency setting. I'm sure, as you recall, late nights from clerking are always there. And so in some sense, none of this is terribly new, and that the court has often dealt with cases on an emergency basis. We just sort of, obviously the COVID cases and election cases that can come up more sporadically, but some of this is not terribly new at all.
Certainly. Yep, I agree. So then we have a bit more about the shadow docket, what people are saying about it, and what Justice Alito is saying about it, in particular, defense of the court. The suggestion that these emergency rulings definitively decide important issues is false. I think he's there talking about not the inherently emergency. I mean, clearly the capital cases that come up, there's either a stay of the execution or there's not. So that's important and it's definitively decided. But I think he means he's denying that they're really making a lot of new law in fields that haven't been traditionally emergency. And it'll be interesting to see how that really plays out, I think. That's very up in the air. And it's been relevant to the abortion cases, maybe most famously and most recently.
Yeah, and I can speak to that for a second. You know, folks probably saw in the headlines potentially about the Texas law that was recently an emergency petition to stop it, went to the Supreme Court. And in her dissent to the court's, the majority ruling, which basically said, you know, we're not going to get involved at this stage, Justice Kagan wrote that today's ruling illustrates just how far the court's, quote, shadow docket decisions may depart from the usual principles of appellate process. That ruling, as everyone must agree, is of great consequence. And so I think, you know, that's really been the first time that I'm aware of where another justice is actually calling that out, right? It's not just the media attention that we see on the slide. I think, you know, part of that is just the highly unusual nature of the Texas law, and the fact that, you know, it was expressly passed in a way to evade judicial review in some ways, in the fact that you know, private citizens were deputized to enforce it rather than the state. So, you know, I think some of that is unique to this highly contentious abortion cases that are before the court. But I did think it was interesting that some of the liberal members of the court, you know, themselves are challenging the court's own practice. You know, so it's not just from the outside.
Yeah, and I mean, it does seem like a change in what they're doing. In my experience, it seems like the number of cases that are being brought to them, which they're not in control of, obviously, but the number of requests that are made are greatly up, especially in areas that are not the traditional emergencies. And then maybe in what they're doing with them, it's a little different. I mean, traditionally, they would just sort of grant or deny. There wouldn't be any real opinions. There wouldn't be anything much said, so there wouldn't be as much kind of grist for the mill that important decisions are being made or not.
I think part of this is connected to the rise in nationwide injunctions early in the process. It's been well documented, the increase in those types of injunctions, particularly against federal actions of various sorts in the last 4 years, and those often came up in emergency stay-type proceedings, and there's more pressure on the court to act if you've got one trial judge holding up a presidential or federal action. So I think that's part of what's happening.
Yeah, that's really interesting, and I think part of that maybe is attributable in part to, you know, just the highly charged, you know, political world that we live in the past, you know, 5 years, which then the world was turned upside down with COVID. So, you know, it may just be sort of the moment that there's a lot more of these, you know, super visible and contested issues that are, you know, making their way to the shadow docket.
Sure. All right, let's do some quick statistics before the cases, just to set the frame for this coming term. So last year was Barrett's first term. And what happened somewhat predictably, you can see here, the little red line is 5-4 cases, which had gone up and then went down. The 6-3 cases is the somewhat hard to see, but gray line that has gone up. So as there are now, for a long time, the court was generally 5-4 in a lot of things. Now it may be that based on the Republican and Democrat appointee divide, it's going to be a little more of a 6-3. difference. So in terms of opinions written, this is always interesting to me. So what jumps out at me about this slide is the number of concurrences. And there's really sort of a philosophical almost divide between the top 5 and the bottom 4. I mean, everybody writes a similar number of majorities. They get assigned those, or they assign themselves. That is always going to be that way, and it's always going to make sense. Everyone's going to have at least a couple of dissents where they're writing not only for themselves but for others. But just sort of the varying philosophies, and not right or left or conservative or liberal, but just the philosophies about who wants to concur, which is always a decision that's made by the justice himself or herself. It's often written for the justice alone, and it just reflects. So, I mean, what you have here is Justice Thomas writing an opinion, and Sotomayor essentially the same, writing an opinion in something like a third of all of the cases. Whereas at the other end, you have Roberts and Kagan. Barrett is new, so she may not have a philosophy on this yet, but obviously Roberts and Kagan have been there a long time. They don't concur much.
Interestingly, Justice Gorsuch, if I recall correctly, in his first full term, wrote something like 23 different opinions and came in right under Thomas. And so certainly if you compare even early in the terms, it's interesting that Barrett has written as little as she has.
Yes. Barrett's number down there reminds me of Kagan's first year when it looked sort of like that. I mean, she was assigned a few dissents. She wrote basically her share of majorities, minimal concurrences, just sort of figuring it out, getting her feet wet a little bit. And
she sort of famously has not written very much since then, too.
Right.
She almost never concurs.
Right. Yeah, so in her now, that was, I guess, her 10th to 11th year on the court, still like one concurrence maybe. Yep. All right. So then, right ahead of talking about the cases, we have this, the frequency and the majority. Statistics like this are where you get the general press idea, I think, that Kavanaugh is now the center of the court. For a long time, Roberts was the obvious center of the court. When Ginsburg was there and before Kavanaugh was, Roberts was in the center, and Roberts was at 97% in the majority, sort of a bellwether. And now the fact that he's fallen, that may be the lowest percent in the majority that he's had in years and years, many years. But you can see now that sort of as Kavanaugh goes, so the court goes in a lot of cases. I think that's interesting. It's also notable to me that you see the new Kavanaugh, Barrett, and Gorsuch, the Trump appointees, they're not, this isn't a philosophical scale exactly, so you can't say, but they are closer, it seems, to the center. And you still have Alito and Thomas with their long experiences sort of out there pushing the flank on the right in terms of less frequently being in the majority, saying their own thing more, and then you have the block in the middle.
Do you think that some of that is attributable to just length of time on the court and time to sort of feel comfortable with their positions? With Thomas and Alito having been on the court some of the longest, I just wonder if perhaps we'll see that shift from the newer justices over time.
Maybe. I don't know. I think that's interesting. I wonder what this would have looked like in the very early terms, It's not quite still a very early term for Gorsuch or anything, but what Thomas would have looked like, say, in his first year, or Sotomayor in her first year, I'm not sure.
Yeah.
It's interesting. I
just think that there's, especially given the fractious nature of some of the confirmation hearings and just, as you were saying, Caroline, the sort of charged climate, I wouldn't be surprised. I mean, I think most federal judges and justices have some desire to, to meet in the middle where possible, or at least kind of be good members of the court community. And so I wouldn't be surprised if there was at least a little bit of an incentive for newer justices to, within the bandwidth of their, judicial philosophies, sort of come to the center early on as they're trying to make their place in the court?
Well, this term might be a great test of philosophy.
Maybe it's wishful thinking.
Maybe
We'll see.
it is. We'll find out. Okay, the court's approval rating, last statistical thing. The court's approval rating, according to Gallup, is now at the lowest since it's been recorded. But what's interesting to me more than that, even that particular stat, is the numbers where it has trended right down and come in. The dip to 42 in 2005 is after Kelo versus New London, a fairly famous eminent domain case that pretty much nobody liked the outcome of. In 2013, although actually notably somewhat unpopular decision in 2010 in Citizens United doesn't seem to move the needle much. But then in 2013, it sort of bottoms out about the time of some gay rights decisions. And then this 42, to the extent this is a dramatic dip, in 2017, there was an affirmative action case about higher education that was fairly unpopular. And then recently we have the dramatic drop-off right around the time of the Texas abortion ruling. So there you go. So I don't know that there's a whole lot to take from this, but it is interesting that the court...
Looks like Bush v. Gore was a very popular opinion based on these numbers.
Yeah, there you go. It is interesting. I wonder, I guess they started here. I wonder if in 2000 what that would look like. But yeah, doesn't exactly match the popular vote count, but I wonder who the Gallup poll is asking exactly. But this is what they put out. So there you go. All right, so cases in the current term. And the first case we're going to talk about from this year is New York State Rifle and Pistol Association versus Bruin.
Well, this is a bit of deja vu for people that remember 2 terms ago when there was a different New York State Rifle and Pistol Association case, also the plaintiff, that involved a challenge to New York City restrictions on traveling with firearms. And that case essentially got mooted out by changes in the laws, and then the court, while having the case on the merits, more or less punted. So they've taken this case, which is noteworthy because it's the first major gun case, really, that they've taken since they decided Heller in 2008. 2 years later, they incorporated that against the states in McDonald, and then they have steadfastly denied a whole bevy of cert petitions, really, going forward. Heller is a very interesting decision in that it focuses on the history and tradition analysis. Justice Scalia, probably one of his most noteworthy originalist decisions. And then since then, the lower courts have been grappling with how to apply that decision to numerous different gun laws. And so they've finally taken this case. It involves a challenge to New York's requirement that you get a license to carry a handgun essentially at all outside of the home, and that's because open carry of handguns is prohibited, and the only way you can carry concealed is if you get a license, and that license is difficult to get. You have to show proper cause, is what the law says, and that's been interpreted by the state to essentially require you to show a specific need for self-defense. And they've actually explained this in a way that says that you can't just desire to defend yourself like any other citizen. You have to have some very specific threat that applies to you to get the license. So these plaintiffs, like many others who have applied, have not been able to get a license to carry concealed outside the house. There's going to be interesting questions on how the court resolves this. I think there's a lot of pressure on the court to answer with a legal standard that can apply to other cases, not just this one. There are a lot of other Second Amendment cases percolating. I think there's a chance that they muddle it a little bit and don't actually give those lower courts guidance. A lot of the lower courts are trying to analyze this in some form of intermediate scrutiny or ends means analysis. A lot of the pro-gun groups are pushing back against that and trying to make it sort of more of a unique historic-based analysis. A lot of amicus briefs in the case, as you would expect, 47-4, 34, 47 for the petitioner, the gun owners, and 37 for New York. The one that's gotten the most attention is probably the Michael Ludig, Carter Phillips brief, where kind of two more noted conservatives in the past, who came out in favor of New York State, and that brief kind of focuses on arguing that there's historical precedent supporting this type of restriction.
I think it's interesting that you point out that a lot of folks are hoping that this will clarify Heller and how it should be applied in the lower courts, because the cert petition was granted on a little bit of a different question than the one that the petitioners raised, and what seemed to me to be a narrower, kind of more fact-specific question on the specifics of the New York law and whether the specific licenses that were denied in this case were denied in violation of the Second Amendment, as opposed to kind of the broader question that petitioners had presented about whether the Second Amendment would allow the government to deprive citizens of their right to carry a handgun outside the home. And so, to your point, I think it suggests that maybe, regardless of what everyone would like, including the lower courts, the Supreme Court may not be willing to go quite as far or make quite as large of a pronouncement as some folks might want.
Yeah, I tend to think that the court took this case to decide it on the merits in some form, and that the change they made to the question presented was more along the lines of how they will sometimes change questions they think that have been overly slanted towards one side. So Paul Clement, very capable advocate, did sort of focus his question presented on the right to carry outside the home, which is one of the stronger ways for his clients to frame the issue. And so they've taken that little part of it out of the question presented, but I think they're going to decide the case essentially how they want to decide it, regardless of that change in the wording to the question.
I mean, so is the broadest thing they could reasonably do here related to gun rights to say, well, we're establishing a mid-level scrutiny for these in general?
That would probably be viewed as a step back for the gun rights advocates if they lock in intermediate scrutiny, because most of the lower courts have been applying intermediate scrutiny fairly hostilely towards guns rights, so they've been losing most of those challenges. It's an interesting law in that only a handful of states have these kinds of restrictive license regimes, primarily on the East Coast and the West Coast. Something like 43 states don't have anything like this. And so in that way, it's a narrower decision, but because it's the Supreme Court speaking about the Second Amendment, everybody's going to be mining the opinion for how they describe the right and how that could be applied to all of these other various challenges, including to a lot of the federal gun laws. There's little quirks about that have been subject to challenges and been drawing some attention. So I think if they announce an intermediate scrutiny standard, that would make a big difference in the lower courts below, but would probably not be as pro-Second Amendment as some other ways they could write the opinion.
I see. Interesting. All right. That's Bruin. Next we have Concepcion versus United States. That's Ashley.
Yeah, and definitely the most interesting picture, I think, selected for our talk today.
Win.
Yeah. Well, so Concepcion in Maxwell, these are companion cases that have not necessarily gotten the same level of attention as some of the other blockbusters that we have this term, but that could potentially have some pretty important impacts on federal prisoners and their sentences. So just as background, I think most people are familiar with the fact that there's been a lot of critique in the past few decades over federal drug sentencing, and in particular the disparities in sentences imposed for crack cocaine offenses versus those imposed for powder cocaine offenses that are pretty, I think, that are pretty widely considered to have been unjustified in the disparity. Much longer sentences for crack cocaine, which ultimately disproportionately affected defendants of color. And so in 2010, Congress entered the Fair Sentencing Act, enacted the Fair Sentencing Act, which made the disparity much less severe. And then 8 years later, it enacted the First Step Act, which, among other things, made those provisions retroactive so that defendants sentenced under the prior, more arduous regime could receive sentencing reductions. But there's been a lot of attention in the federal sentencing circles about whether and how that act should apply. So in these cases, in the First Circuit case, which is Concepcion, the district court or the First Circuit permits district courts to consider any intervening developments and changes to the law. So that would include changes to the sentencing guidelines and also any court decisions that change how those guidelines or any statutes are interpreted, and then that they could take those things into account when considering whether to reduce a defendant's sentence under the First Step Act. And then on the other side of the coin, the Sixth Circuit and a few others have held that a court may but need not consider those developments. It essentially leaves all of that up to the court's discretion. And then there are a few circuits that go even further, like the Ninth, and those circuits explicitly say that district courts cannot consider any changes. They may only consider the changes expressly contained within the First Step Act when they're deciding whether or not to reduce a sentence for a drug conviction. So, I mean, the circuit split really ends up making a big difference to defendants that are sentenced in these different circuits because, for example, in the Fourth Circuit, where courts are obligated to consider any of these intervening changes, more than 1,000 First Step Act motions have been granted. More than 1,000 federal defendants have had their sentences reduced. And then in the Ninth Circuit, on the other hand, where courts can't consider those developments, they've only granted motions in 162 cases. So I think it'll be interesting to see how the court resolves this. I think what my prediction is that the defendants, the federal defendants, will win in that the court will say that you may consider the intervening developments. But I think there's going to ultimately be an emphasis on district court discretion, that the sentencing judge is in the best position to decide whether any particular defendant should receive a reduction. So, I don't know that it's going to make a dramatic sea change for most federal defendants, but in those few circuits where all of these changes in the law cannot be considered, it could make a difference for them. And this, the picture is, of course, Kim Kardashian with former President Trump. I think you all probably remember that there was some media attention over her prison reform efforts during the Trump administration. She pretty famously had a grandmother pardoned or encouraged President Trump to pardon a grandmother who had received a life sentence without the possibility of parole for a first-time nonviolent drug offense under the prior federal sentencing scheme.
So is this ultimately a question about the text of the First Step Act? Like what the text of the First Step Act permits the district judges to consider? So it's a textual analysis?
I think that's how the court will handle it. I think there are some of the lower circuit court opinions rely really heavily on sort of the remedial purpose of the act and maybe not picking apart the specific text of the language of the specific provision allowing the district judge to reduce a sentence. And so they may be importing a little bit of that purpose into that specific section. So it'll be interesting to see whether the court focuses on the language about what the district court, the sentencing court, can do or may do, versus sort of saying how should they interpret it in order to implement the remedial nature of the First
So
Step
probably
Act.
what got the court's attention is just the vast disparity in how it's being treated.
Yeah, I think so.
Regardless of what they really think on the merits. It comes more from the need to resolve the split than anything else.
Right. I think there's probably some reasonable concern about a defendant in California versus a defendant in Virginia receiving an entirely different treatment under the act.
Sure. All right, let's go to Ramirez.
This is one of the death penalty cases that has come up originally as an emergency stay that we discussed earlier, and they stayed the execution in Texas and took the case on the merits. And this has to do with the the inmate's desire to have his pastor in the execution chamber and to have him lay hands on him, and probably also claiming that he should be allowed to audibly pray during the execution. There's a bit of a back and forth going on between the courts and Texas on this issue. And they originally, the case came up only a couple years ago when they were excluding non-Christian pastors or spiritual advisors from being in the execution chamber. Texas lost that case with a Buddhist monk being required to be allowed to be in the execution chamber. They responded to that by saying that no spiritual advisors were then allowed to be in the execution chamber, which was a bit of a change since Texas statutory law had actually required chaplains to be present for a long time before that.
But only Christian chaplains.
Oh, yeah, exactly. Only certain faiths as chaplains.
Got it.
Then a case went up again last year. Alabama and Texas were the only two that had this strict prohibition. They lost again, and it went back, and then Texas has sort of reluctantly allowed spiritual advisors to be in the chambers again, but they've put these restrictions on what they can do in the chambers. And so this case falls under RLUIPA, which is the federal statute that imposes kind of a stricter free exercise standard on the courts when they're dealing with inmates. And I think, given how these cases have tended to come out, that Texas is pretty likely to lose this case now that they've taken it.
Yep. I thought it was interesting about this case. It seems like Texas runs into quite a problem because other states and the federal government allow the spiritual advisors. So in terms of the strict standard under RLUIPA, like how they can, it seems like they'll have a hard time defending it, given that other execution processes and even their own state have historically allowed it.
Yeah, I think that's right. The question is going to come down to which of those other states or federal protocols allow what this particular pastor is asking for, which is a bit of an unusual request to lay hands on the inmate literally at the moment he's dying. And it's not as clear that Texas is really an outlier if you narrow the question all the way to that point. But in terms of allowing spiritual advisors in and allowing prayers, audible prayers to happen, I think Texas has got an uphill battle in terms of the facts. And certainly the recent history doesn't help them. It makes it look like they're kind of trying to cut back on these religious rights in a way that they really haven't done historically.
All right, let's go to Dobbs. Caroline?
Great. So the first thing that I want to say is that Dobbs is not the Texas abortion case that has been all over the news. I think Dobbs is actually more important to, abortion access in this country, but it hasn't gotten quite the media attention, I think, because of how unusual the Texas law is structured and the fact that it, went to the court in an emergency posture. It's really garnered a lot of attention. But what we really, and we're going to try to talk about that at the end, but I think we're going to focus on Dobbs, which is a case that has come to the Supreme Court not through the Shadow Docket, but through a regular petition. And it's a challenge to Mississippi's law, which bans almost all abortions after 15 weeks. And it's really the strictest abortion law in the country. And it's pretty clear, and the lower courts both held that this law is unconstitutional, right? It violates Roe v. Wade and Casey versus Planned Parenthood pretty much on its face. Roe establishes the constitutional right to abortion, and Casey set up a framework that everybody's probably somewhat familiar with, that focuses on the viability of the fetus and whether or not a state's restrictions before viability are an undue burden on the woman seeking the abortion. So it's really interesting, I think, that the court took this case on, and that's that's really a huge potential signal about where the court is going. States pass laws like this pretty frequently and have over the past, many years. And the Supreme Court has pretty consistently declined to get involved to laws that facially violate Roe. They've let the appellate courts strike those laws down and have not inserted themselves by taking one of those petitions. And so a lot of people, and I think rightfully so, are reading into this grant that the court is ready to take a significant position and likely a change position on Roe and Casey. So I want to talk some about our predictions of what's going to happen here, as well as some of the implications of a potential decision. But first, I'll just note, timing-wise, the argument's going to be December 1st, and I think, it's likely to be the most watched Supreme Court argument, I think, in recent history, just given, a lot of the media attention around the country. And the opinion will likely come out at the very end of the term in June. So I'll talk a little bit about my prediction, and then I'll let my colleagues weigh in as well, because I think we have some differences of opinion. I think that it's likely that the law will be upheld, meaning that the court will make a significant change in the law. I'm not convinced that the court will go as far to overturn Roe v. Wade. I think justices in the middle, particularly Justice Roberts, Justice Kavanaugh, potentially Justice Gorsuch, may not be willing to overturn that precedent so explicitly. I think there's a way that they could uphold the ban by recasting Casey and the undue burden standard in a way that allows states to pass a lot more onerous abortion restrictions, but that does not eliminate the constitutional right to access to abortion. But I'm going to pause there and see what my colleagues have to say.
Ashley, what do you think?
Well, my opinion is, I think I agree with Caroline ultimately that I think the fact that the court took the case and framed the issue the way that they did likely suggests that they are interested in taking a position on Roe and potentially are willing to take a big bite out of the right to abortion access as we currently understand it. What I'm really interested in is to see how they do it and whether they're willing to go with any of the arguments that have been presented, kind of the more extreme positions that have been presented with the 14th Amendment and historical arguments about the scope of individual liberties and constitutional rights available under the Constitution, because I think there could be some more wide-reaching implications if they go that route. But I think ultimately it may be a more fractured, narrow opinion. The ultimate opinion may be a little bit more narrow than that.
What do you think they're going to do?
I think they'll do something that will make everybody unhappy to different degrees. They took something like 17 conferences to take this case between rescheduling and setting over, and that is unusual in a case like this where presumably the justices are pretty well know what they think about this issue. So it's hard to tell what that means other than I think there's certainly a lot of tension within the court on how they're going to handle it. I think that the law will be upheld in some fashion, but that they'll have 8 or 9 opinions, possibly not even a majority opinion, and it will make some sort of a mess of what's currently viewed as the Casey regime. I mean, Chief Justice Roberts already in some ways, floated a trial balloon in June Medical about, how he thought Casey could be reimagined, and he essentially had 0 votes at that time for his view. So I don't know what exactly the answer is other than some sort of word salad.
Oh, I think, yes. I think word salad is very likely, if not unavoidable. We had a question relevant to this, which is, does stare decisis not apply to the Supreme Court? And that is a very short and simple question with a very complicated answer, but ultimately, on constitutional issues, whether stare decisis applies in any given case is up to the justices in that case, which is sort of like saying it doesn't apply. Some of them think it applies, some of them think it applies to various degrees, but I think few of them would say, if any of them, probably none of them would say as a categorical matter, yes, stare decisis always is what is our ultimate guiding light in a constitutional case. So what do I think? I'll take the edge here, and I'll say I think that they're going to strike down Casey. I think they're going to go back and say something like there's not a constitutional right to an abortion. I don't know how likely exactly that is, but I'll go ahead and take that position. I think there's at least a decent chance of that. So we know this is what we know. Justice Thomas, in opinions, has said he thinks the whole idea of a constitutional right to abortion is bunk. So there's a flag planted on that edge of the court, essentially, already. We know it's unrealistic to imagine that he will depart from that. We also know that we have now, we know that Chief Justice Roberts would not be a reliable vote for a position like that, but we also know that there are 4 other members of the court who might be. And we know that those recent members of the court especially, I think, have been selected with at least one eyeball on this issue. That's not to say anyone knows for sure what anyone is going to do, but I think it would be hard to ignore that these justices were picked with cases very much like this one, if not something like this, right in mind. And I think it is interesting that it took 17 conferences to grant this. There are a bunch of different possibilities, things that could mean. One of them is it took them 17 conferences to hash out basically what they want to do, and now they're going to do it. I thought it was interesting in particular that they only granted the first question presented. So there were several questions presented, the first being the most categorical of them, and the others were talking about Casey, sort of offered more just paths and ways out, essentially.
Right, escape hatches. More
escape hatches, and they still could do that. I mean, there's nothing that binds them to a simple answer to the question that they granted. But it strikes me as a tell of some kind that they didn't just say, okay, we'll take this as the parties have set it up, why not have the second and third questions presented, that they sort of crafted what they want to take in a categorical way. I think you can interpret something from it.
Yeah, and I think, it really is going to come down to, as Matt said, the couple of justices that we just don't have an indication of what they're going to do. And you can, really try to read the tea leaves. And, of course, the confirmation hearings, there were a lot of efforts to get the justices, the new justices to speak to this. And, of course, they, didn't say what they would do. I think probably the strongest statement was Justice Barrett recognized, there are certain decisions like Marbury versus Madison or Brown v. Board that would be considered super precedent, which is sort of a made-up term, but I think signals that sort of accepted law. And she indicated that she did not think that Roe met that definition. So, that's, I think, sort of the most insight we've seen from one of the new justices. Justice Gorsuch has not written much in his days on the lower court on this topic. Justice Kavanaugh had one major abortion decision that was talked about a lot, but, you know, it's really just hard to know exactly where they're going to go. I think
everybody wants predictions, but, you know, if we were doing this panel in 1992 before Casey met, you could have said almost the exact same thing, that there were now 6 justices selected with an eye on this issue. Certainly President Reagan and to a certain lesser extent President Bush, you know, viewed this as the issue defining the Supreme Court. And Justice O'Connor at that time had written essentially concurring or dissenting opinions in Webster, where she threw substantial doubt on Roe before Casey, and then sort of famously that case did not turn out as people thought, which is not to say that I think that same type of outcome is going to happen this time, but just that this topic, really more than any other, is impossible to really predict.
I think you're right about that for sure. This may be the one. It's hard to even come up with another that would be like this. There may not be one.
Yeah, and I know we're getting close to time. We've got a little blurb up there about the Texas law. I think it's worth noting that case may well be on its way to the Supreme Court again on the merits. You know, it first came to the court, like we talked about, as an emergency petition on the so-called Shadow Docket. But there's ongoing litigation in Texas right now. Both the Department of Justice has sued Texas, and then you also have a couple of individuals who have brought cases attempting to enforce the law. And the case between the Justice Department and Texas, you know, there's been late-breaking developments the past few days. A district court judge blocked the enforcement of the law, and then that was reversed about 2 days later by the Supreme Court, by the Fifth Circuit. And so there's an open question of, you know, what the next moves of the parties are going to be, when they're going to try to seek Supreme Court review again. But that's just something to be watching for as well if you're interested in all these battles.
Let's see if we have any other questions to comment on here. So one of them, there's one question that that goes back to the frequency in the majority slide and asks whether it disregards concurrences and includes them as in the majority. And the answer is basically yes, that the concurrences are part of the majority. So when you see, say, Kavanaugh 95% in the majority, that would include any separate decisions that he wrote. We also have a question. What are your thoughts on the relatively small number of full decision cases that the court is taking and deciding each term? Are they leaving more circuit splits unresolved? Anybody thoughts on the shrinking merits docket at the court?
There's a smaller number of circuit splits than there used to be for reasons that people don't fully understand, but certainly the shrinking docket is of interest to people, although sometimes people think that when they take cases and get them wrongly decide them, that you shouldn't have a large docket. So it kind of cuts both ways.
Yes, how much you agree with what they're doing may depend on how much you think they should be doing at all. That's for sure. I do think there are a lot of new justices on the court recently, and sometimes new justices bring new blood. You know, there may be issues boiling around that there have been 3 votes to take and now there'll be 4, or maybe there were 4 to take it, but until they had what they thought would be a 5th on the merits, they wouldn't take it. You know, so sometimes the new blood could yield more grants, but that hasn't seemed to be true so far, and we'll just have to see what will be on that. Let's see. So there is, the last question we have is, what rules govern outside speaking engagements for sitting Supreme Court justices? And the answer is, you know, the justices accept outside speaking engagements more or less as they want to. They tend to go to universities. Some of them don't like their remarks recorded for whatever reason, but they welcome the press to come in person normally to those things. I am not aware of meaningful rules that govern where they can go or what they can say.
There is a financial disclosure that comes, and so it will often get in the news that a justice was paid such and such to teach a class, or I forget what the threshold is. There was a debate, whether a pair of cowboy boots or something exceeded.
Right.
The
It's relatively small.
Yeah.
Right. So they certainly don't make meaningful money from any of their engagements. But in terms of what they do that might create an impression of partiality towards one side or group, it's pretty much up to them what they want to do. Yep. Okay. Well, that's all the questions that we have and all the time that we have for cases. So thank you, everybody, for logging in and joining us. We very much appreciate your time.
Thank you.